Hello, this is Greg Giardino and Steve Craffen with Atlas Fiduciary Financial. And today we want to talk to you about one of the biggest estate planning mistakes that we see made, and that is not having a proper HIPAA release authorization. Let's talk a little bit more about that. I'll pull up my slides. All right, so let's talk about a hypothetical scenario. There's a mother and a daughter, and the daughter notices that her mother is starting to get forgetful and that she's not paying her bills on time. A couple months goes by, and the daughter gets a phone call that the mother has been admitted to the hospital and that she's incapacitated. So the daughter drives to the hospital and asks the doctor, well, what's going on with mother? Is she okay? And then the doctor asks for the medical power of attorney, which basically would designate the daughter permission to get access to her information, as well as administer her care. However, upon further review of the medical power of attorney, there's no expressly written HIPAA authorization. So the doctor uses his discretion and decides not to disclose the mother's current health information to her, which is that she's been diagnosed with Alzheimer's disease. So this can create a very, very scary situation and can really delay the caregiving process.
And there
So
could be a couple reasons why there's no HIPAA authorization. The first is if the mom's documents have been drafted a long time ago prior to Congress passing the HIPAA law, it may not have been incorporated in her documents. And the other reason is sometimes you go to an attorney and the attorney just leaves it out, doesn't even think about adding it in. So it could be for a couple of reasons.
So yeah, this can create a very scary scenario, and we'll talk a little bit more about HIPAA and what that is.
Yeah, and so I'm not going to read what it is. It's another one of those acronyms the government comes up with, but it's a law that regulates who can get your medical information, and privacy issues associated with it. And so a doctor, may not be able to legally release your medical info without this clause in a medical power of attorney. Now, generally, they're supposed to release it to a spouse, but you may encounter a caregiver that's not familiar with that exception or may not fully understand it. So they may still be really cautious about releasing anything to a wife, if it's the husband that's incapacitated or vice versa. And so it really behooves you to make sure that you have this provision incorporated in your legal documents. And by the way, it's something we always check for when we review your legal documents.
And just touching base on this, when we do review those documents, typically when we see if the documents haven't been updated since 2003 when the HIPAA law was passed, then more times than not, we know it most likely does not have a HIPAA authorization. So
Yeah.
it's important to get these documents updated regularly. So the take-home point, make sure as part of your comprehensive estate plan that you have a HIPAA authorization. And Steve and I would also suggest that your medical providers, your doctors, they have a digital copy of this on file so that if there is, God forbid, an emergency, they can communicate serious medical information and aid in the decision-making process.
And I just want to mention, we have the ability to review all your legal documents in a very efficient fashion. And if you're interested in having us do that for you, certainly give us a call or send us an email and let us know.
We would be happy to help. And we hope you found this information valuable today. And until next time, we'll see you soon. Take care.